Right, and we are back here live with Stan Perchowski and estate plan Stan, as I should say. Easier to say.
That's right. It's easier to say, and it's a lot easier to spell.
Easier to say, and with all that is estate planning, and of course it is the estate plan Stan hour here on WDXE.
Yeah, we call it bulletproof estate planning.
That's right.
And again, before we get started with our topic, I will encourage folks to call in.
Yes.
Okay. And that number is 931-766-9393. Kind of an easy number to remember.
Yes, indeed.
Over here in Lawrenceburg, it's typically 766 or 762. Anyway, call in with a question on anything. It doesn't necessarily have to be the topic I'm talking about now. It can be a past topic, and sometimes it's even a future topic that I haven't got to yet. But no problem. It's cool. We encourage questions. I always do. I got a seminar coming up. I'll just start with that. It's going to be a little while. It's the end of July, and it's on a Saturday again. I mentioned last week that we seem to be doing more Saturday ones because just by popular demand, it's a more convenient time for folks to come. So it's July the 29th. So it's at the end of July. That's a Saturday. We do Saturday ones at 10 o'clock in the morning, and we're going to be doing it right on the square in Pulaski at the Star Theater. I mean, you can't miss it on the east side of the square. So Saturday the 29th at 10 a.m. If you want to RSVP for that, please do. So we have an idea of a head count. Somebody called one time at this last one we had last week that we had here at WLX. And they called me and said, "Is it too late to register for the seminar?" And it's like, well, it's not that formal of a thing. The only reason we like RSVPs is because, here like at WLX and at the theater, we set up tables and chairs. And I don't really want to be scrambling at the last minute, pulling out more tables and more chairs, because we do get a lot of walk-ins and stuff. So we account for that. So we just like a head count because Miss Tammy likes to make some light refreshments. So it's really informal, and it's okay to just walk in if you can't say, well, I'm sure I'll be there. I know some people at the last minute, it's like, okay, it looks like I have time to go to that, and they just show up, and that's okay. That's welcome. But, we always have a question and answer period during those seminars, and I tell people, I encourage that, because when I'm at these seminars, I'm offering my time freely, and I say take advantage of that. So if you have a question at this, before you come to a seminar, write it down, bring it with you, and if you develop one during the seminar, which most people do, ask it, and we'll take care of it. So same thing with this show. If you have something and you think about it during the week, write it down. If you tune in, go ahead and call in. It doesn't have to be exactly on the point I'm discussing because, as I discuss this stuff, I told you in the beginning, it's kind of a progressive map. We kind of flow through from topic to topic in a progressive sort of way. But you can bring up anything about this, and I'll be glad to talk about it. So questions are always welcome. Don't feel shy or uncomfortable, because and here's another thing about questions. If you think of a question, I mean, you've done this, Jeff.
Yes.
If you think of a question and you ask it, I guarantee you there are many other people out there with the exact same question on their mind.
Absolutely.
And I know that because when I have these seminars, I tend to hear the same basic kind of questions most of the time, and
yeah.
I get it, and that's okay. So let's get it out, let's get it addressed, because if you ask it, some other people are thinking about it, and they'd like to hear the answer too. So that's the seminar coming up. Let's see what we talked about last week, and I was telling you off mic that I need to keep some notes because I was on the way over here. I thought, okay, can't quite remember where we left off last week because we had some questions and we were talking about some stuff, but it sort of came to me. But I like to keep notes so I don't skip over anything. And I think what we did was we had progressed through the last will and testament. We talked a lot about the probate process, and then we moved into the other form of estate planning, which is writing a trust. And the one trust we were talking about was the revocable living trust.
Yes.
And we talked about if you make a revocable living trust, it gets its name living trust because it goes into effect now during life, whereas a last will and testament only goes into effect at death, which is what the word testament means. So you make a revocable living trust and you fund the trust. And we talked about funding was the process of moving property from your individual name into the trust. And we talked about the fact that, this concept that people use, and myself included, it's a typical street vernacular to say, oh, it's in the trust. My house is in the trust, or my bank account is in the trust. We use that terminology because it's easy to think about something being in the trust, but there really is no such concept as in the trust. What in the trust means from a legal standpoint is we take the piece of property and we vest it with the trustee. So I think we used the example, if it's myself and I have a revocable living trust and I own some property like a deed and it's deeded to Stan Pierchoski, the individual, the way I put it in the trust is I create another deed, and now this new deed is from Stan Pierchoski, and it's a quitclaim deed, and it's to Stan Pierchoski, trustee of the Pierchoski Living Trust. Now, what I've done with that new deed is I've taken that piece of property that was outside the trust and have now put it in the trust by vesting it with the person that controls the property in the trust. So that's in the trust. I think that's kind of where we left off, but
Yes.
when we fund a trust, we want to put all our property into it, because remember, this trust is a probate avoidance technique, and the only way to have 100% probate avoidance is to have a fully funded revocable living trust. So that's how you put your land in there. Now, when you put your land in there, everything is exactly the same, because if you go to the bank and you say, hey, I did one of Mr. Stan's trusts and I want to put my checking account in, my savings account, my CD, the bank will say, no problem, we know just what to do. I mean, banks are no strangers to trust law.
Yeah,
Almost
absolutely.
every bank has a trust department. And so they know, and they'll say, okay, what do you want, what's the name of the trust? And they will change the bank account from Stan Pierchoski to Stan Pierchoski trustee, just like that deed, okay? And so all the property gets funded that way. Now, there are some pieces of property that don't necessarily go through probate in the first place, like a beneficiary-driven instrument, like life insurance is a classic. If you have life insurance, you don't own anything. You have a death benefit that goes to someone else at death.
Yes.
I'm talking about term.
Yes.
And so you don't really have any ownership in that. So it's a beneficiary-driven instrument. So you can say, if you say on there, okay, my son gets, this $100,000 life insurance death benefit. Well, that doesn't pass through probate, because my son makes a claim with the insurance company and they just cut a check and send it to him. And so, a lot of people will say, and insurance companies, God bless them, they're fun to deal with, and maybe I'm a little cynical, but here's the way they work. And once you get the hang of them, you kind of can work with them. But I had this gal one time, an elderly gal, and she had these life insurance policies. And she was concerned that one of her children was somewhat of a spendthrift, She thought, I don't want him to just, if he gets a big check from the insurance company,
Yeah.
he's just going to blow it, I mean,
Yeah.
she was just cutting to the chase and said, he's just not very financially responsible, is a good way to say that. And he would
Yes.
just blow it. And that's not why I want to leave him an inheritance. I want to leave him an inheritance so he can maybe buy a new home if he needs it, or start a business, or higher education, a good start kind
Sure,
of thing.
absolutely.
And that's what most people think. And so she was afraid, and she called whoever it was, XYZ Life Insurance Company, said, listen, I have my three children as beneficiaries, and the one son's not very good with money. I kind of don't want him to get it all at once and stuff.
Yeah.
And she told me, she said the fellow was borderline rude and said, look, lady, he said, basically what he said was, we've got an obligation to pay, and on a qualified death, and he makes a claim, that's what we're going to do. I mean, I'm sorry about your son. I hope you can fix that, but we're just going to cut him a check. That's what we do. And he's right, okay? What happens with this beneficiary instrument is it passes by contract, okay? You have a
Yes.
policy, and you say, when I pass away, I want my death benefit to go to my kids. And that's
Yes.
what they'll do. Once they jump through the hoops and prove who they are and prove you're really dead and it wasn't suicide, the drill.
Right.
And once you do that, they'll pay. And so they'll just cut a check and whammo, you get it. So if you're a spendthrift, that's how you get it. So one of the things we can do to protect that, let's say you have a spendthrift and you think, okay, the property in my trust, I can put conditions on that, and I'm going to give it to them a little bit at a time, a little bit this year, a little bit next year, that kind of thing. So what we do with these beneficiary instruments to control that is we say, okay, let's not make the beneficiary my three kids. Let's make the beneficiary my trust. Now it's going to go to the trust first. Now the trust will control the descent and distribution, and we can put whatever conditions on it
That
we
makes
want.
sense.
Yeah. So this is this concept of funding the trust. Now, once you do fund the trust with everything you own, and that's the goal, because remember I said if you own anything in your name, if I die with something in the name of Stan Pierchoski, it's headed for probate. Now, maybe one of our abbreviated versions, depending on the size of the asset, but probate nonetheless. And to avoid probate, if it's all titled to me as the trustee, it passes probate free, because now it passes under our trust code, not the probate code. And that's a different scheme of statutory laws. It's non-court intervention, basically non-adversarial. It's a very smooth process. Now, so if we move everything into the trust, which is the goal, then when we pass away, everything's titled to us as the trustee, and so now we have in the trust where it goes, okay? Now, this will solve the disadvantages of probate. Because the first thing I said about probate that was a disadvantage, remember there were 4 things I said were disadvantage. The 4 biggest disadvantages, I can come up with more, but those are the 4 big ones. Are one, it takes a long time.
Yeah.
Statistically, it takes 12 to 16 months in the state of Tennessee. Now, that's kind of a wide range, but, we said it has to take at least 12 months after death because creditors' rights are open for 12 months after death. It's hard to close in a state even earlier than that. Now, in a trust, that can be administered rapidly. I've seen people do it in a couple of weeks. There's no problem. The trustee or the successor trustee now, I've passed away. I've named somebody to be my successor trustee. Their job springs to life the moment of my death. Mm-hmm. And so you don't have to go to court and get sworn in, get letters, testamentary, get the power to do stuff. You have the authority and the power under a trust code the moment of death. So, you hear people say, well, so-and-so passed away, and there's people going in and out the house, and they're taking stuff. And they call the police, and the police say, who's got the authority to lock this place down? And the answer is nobody, because we haven't opened the probate estate yet. What happens is you finally open up a probate estate, you file the petition, you publish the will, you finally get to court, the judge swears you in, and you get these things called letters testamentary or letters of administration. Now you're the empowered person to go change the locks. Mm-hmm. But this is usually a couple of months after death, and the pilfering has already happened. The big difference with a successor trustee, they have this authority instantly. Okay? Now, this person's job is to do what the trust says, distribute the property in accordance with what it says. And They can do it immediately. I think I may have said this example somewhere, but I talk about this stuff so much I can't remember where I said it. But here's a good example. Suppose my son is my successor trustee, and I've passed. And so he wants to, he knows I have this bank account. And he walks into the bank and he says, I want to take control of Dad's bank account. The bank is going to take the position, under what authority are you acting for your father? Mm-hmm. And so he's going to show them the documentation that says he's the successor trustee. He's going to show them a death certificate to show that I'm not here anymore. That's all the bank needs to see. They will recognize that immediately. And they'll say, okay. They may want some proof of who he is, of course.
Sure.
But then they'll say, okay, what do you want to do with your dad's bank account? Well, he'll say, how much is in there? $150,000. Okay, there's myself, my brother, and my sister. Okay, here's what I want to do. I want to write a check to myself as successor trustee, because that bank account is in the trust. Now I have authority over it because I'm the successor trustee. I want to write a check to myself for $50,000, a check to my brother for $50,000, a check to my sister for $50,000, and then I want to close out the account. And the bank says, okay, and he does that. Now you walk out of there, and that asset has been distributed just like that. That's simple. That's
pretty amazing.
That well-oiled machine. Whereas
That's
you want to
pretty
distribute a bank account in probate, you've got to propose what you're going to do, submit it to the court. Everybody has 30 days to lodge an objection or an agreement. I mean, the whole procedure and stuff. Same thing with a deed. Yeah. You're in the real estate business. If I leave my property, let's say I leave the property to my son, who's also the successor trustee. He has the authority to write a deed. Now, you need an attorney to do deeds in Tennessee, but he'll come to an attorney like me and say, I'd like you to draft up a deed that this property, and it's going to say the grantor is from my son, successor trustee of the Stan Pierchoski Trust, to me, my Pierchoski son. My son, his name is Kurt.
Yes.
To him, and then when maybe a little bit of delay because it takes the attorney a couple of days or a week to draft the deed. But once the deed is drafted, he literally signs this deed, and he has distributed the property from him, the successor trustee, that capacity, to himself, the individual, which is what the trust said to do.
Okay.
And that happens just like that. No appraisals. When you're in probate, and like I said, you can relate because in the real estate business.
Yes.
If a person passes away, they're in probate and they got property. Let's just say you got a couple of rental properties, and a lot of people have more than just their home.
Sure.
But most people have at least a home, and so when you're in probate and you want to sell it, or you want to distribute it, or somebody's buying the other one out. I have 3 kids, and if I left my property to all 3 of them, one of them's in Miami and one of them's somewhere else, and the third one is here. If he wanted it, he'd sort of have to buy the other 2 out, right? Mm-hmm. And so, if there's a sale of property going on in probate, they really don't settle for just you deciding what it's worth. You know what I mean? Because the probate court has an obligation to maximize the estate. Their job is the best interest of the estate and protect it.
Yes.
So they're going to want to know what fair market value is. And they'll say, you can sell this, but you got to sell for fair market value.
Right.
Now, in real estate, Now in TennCare, we know what fair market value is. It's established as the tax appraised value on the tax card. But in the real world, out in the third party market, it always sells for more than that.
Well, that's why auctions are popular, or a popular way to do this.
I mean, you're hearing what fair market value is as people are shouting it out, right?
Right.
Or raising their hand, right?
Yeah, kind of establishes market.
So, you ask the question, what is fair market value? The answer is it's what a buyer will pay and what a seller will sell for.
That's correct.
I mean, what is that number-wise? I haven't got a clue. Depends on what we're talking about. Fair market value to you is different to me. You might pay a bunch of money for a piece of property that I'm saying, it's not worth that. I'm not going to bid that much. And maybe it's just I was looking at it from a investment standpoint, but it borderlines your already owned property, and you want to eliminate ever having any neighbor problems, so you want to buy that lot out. You pretty much pay whatever you want. You could need to get it. Mm-hmm. I was in that position. I bought a piece of property here, and there was another piece of property beside it. There was an easement across mine to get to it, and the guy finally decided. I told him if he ever wanted to sell, please let me have first crack at it.
Sure.
And he called me one day and said he wanted to sell it, and I pretty much. He didn't really want to haggle. We haggled a little bit, but I pretty much had already made up my mind. I was going to pay whatever I had to buy it out, to merge the easement and get rid of all that.
That's one of those cases where it was worth more to you than probably anyone else.
Exactly. This had an old beat-up mobile home on it. I mean,
Sure.
There's nothing great about the property, but I said I'm buying it. I don't care what. I'll do what I can to whittle it down, and I did a little bit, but I didn't spend too much time on it because that's what I wanted. So fair market value is a moving target. So the court typically will order appraisals. There's some people that do that, and a typical appraisal is probably in the neighborhood of $1,000 to $2,000, $1,500 or something in that ballpark. Just depends, but so so when you're with the trust, there is none of that. These folks can agree on what that is because we don't have this court intervention. Because if, let's say, you have two children and you leave property to your kids 50-50, just to make it easy. I mean, 50-50 is what those heirs agree it is.
Right.
So, it could be like this. You can say, okay, I want half the property and you can have the property. If we sell it, I want exactly half of the money. Okay, that's 50-50. Or you could say, you know what, I want the property. So how about you take the money in the bank account and the car, and we'll call it even, because the bank account and the car is equivalent to what the half of this property is worth. And if you come to an agreement on that,
yes,
we can satisfy the trust as distributing 50-50. We don't need court intervention for that. The parties are happy. When the parties are happy, what objecting parties are there?
Exactly.
So it moves so much quicker. So that's why we want to put everything into the trust, because when everything's in the trust or everything has been funded to the trust, now everything proceeds 100% probate free. Now, I want to talk about this probate free because it cures those four things I said. The first one was it cures the time. It's very rapid. Very rapid. I've seen people administer trust in just a couple of weeks, and I think one we helped with took about 3 or 4 months. And the only reason they took that long is because this family had some offshore accounts and money in foreign jurisdictions where you got to jump through a few hoops with the Cayman Islands or something like that. But still, it went smoothly. You just have to do what they do in that jurisdiction. But if you have the average stuff, house, some land, money in the bank, some little investment and stuff like investment account or CDs, and maybe even some stocks or something. It's IRAs and retirement accounts. That's the standard stuff. It goes rapidly. It goes very fast. So that's a big advantage. The other big disadvantage I said to probate was the cost. I said, that's all over the board, but some of the statistics I see are pretty a wide range, anywhere from 5 to 10% of the estate. I've never seen them as high as 10. I have seen them in the 6 to 8 range, but nonetheless, you can figure, you know what you're worth. You can figure out what that is, and 10% is an easy number to do in your head. So you can figure out what the probate might cost. But when you do it with the trust, it's a fraction of the cost, and it's a fraction of the cost because of this probate process. There's a lot of, there can be, and this is why it's so all over the board. There can be a lot of cost with the probate system. Just depends on what happens, who the players are. Is anybody disgruntled and wants to challenge? Or you could have a sole child, just one child, the sole heir, where everything goes to.
Right.
And so expenses of the estate are coming out of the same pot that everything's going to. So there's nobody really complaining about it. Those go a little smoother. But but nowadays, it seems to me that challenging these things seems to be more the rule than the exception, like it was. There's a tremendous number of these challenges out there. I refer them out all the time because, people call me and they got a will. I mean, it wasn't one that I did, but they got a will and somebody wants to do it. I mean, I don't do the litigation part of it anymore. So, but we get a lot of them. So it happens a lot. Now, that gets very costly. When you do a trust, it's really a fraction of the cost. And the big difference in the two is I said if you do, the cost of probate is not money out of your pocket because you are gone. But it is money, it's an indirect cost because it's money out of your estate that does not go to the children, right? It get consumed before they get their distribution in the clause that's called the residual clause, okay? And so it's kind of an indirect cost. Now, when you do a trust, I said there is a cost to you now during life because you have to hire someone like me to draft the thing, right? So,
yes.
But it's considerably less in the grand scheme of things. So it fixes the cost problem.
Is there an average cost to try? I'm sure it's all over the board.
It's kind of all over the board what you want to do, but our revocable living trust usually hover in the range of about $3,000.
Okay.
Some of our asset protection trusts, when you get into 10-care, which I'll talk about, probably in a couple of weeks.
Okay.
Those are kind of a little more of a moving target because in those cases, we don't know what we're going to have to do to qualify people until we get to there and know what's available and what the circumstances are.
Yes.
But again. And wills, considerably less than that, but wills do considerably less than a trust.
Yes.
The trust is a grand tool. So there's that. Now, the third thing I said was a big disadvantage of probate. If you remember, I said it's 100% public.
Yes.
They have to publish my will.
Yeah.
You can go get it. You just walk in to the Chancery Court office and say, I'd like to see the estate of Stan Pierchoski. They don't have to ask you who you are and what's your business. They say, okay, here it is. They have to show it to you. You can look at my will. You can see where my stuff is going. I said that bothered me. Maybe because I used to do a lot of criminal work, but criminal defense work.
Yes.
But nonetheless, the trust plan is 100% private.
It does seem like that should be private, but it's not.
It is not. I mean, when you talk about our American jurisprudence system, the only thing that's really most of the time private is some juvenile stuff. Okay, those records get sealed in there for reasons. But other than that, everything is, we are this public system. That's the whole beauty of it. It's all disclosed. And so, you can, like I said, I used to, in my PowerPoint, I used to say, if you don't believe me that your will is not published, I'd hit my clicker and put on my PowerPoint, Jackie Kennedy Onassis' will.
Yes.
I have all the greats, Jerry Garcia, yes. John Lennon's will, stuff like that. So they're there if you want to see them.
I had a quick question. Yeah. How soon after someone passes that has a will and it has to go through probate, how soon do they have to start the probate process?
Excellent question. There's really no time frame.
That's a curious thought.
It is curious. There's really no time frame. Typically, people get around to doing it probably in the 2 to 3 months after death.
Okay.
And usually it's because things are driving that. They starting to deal with the assets or they need them and they can't get at them. Okay. In other words, they got a bank account. They might want to go say, hey, I got Dad's bank account. He named me executor of the will, and the bank will say, well, do you have letters testamentary? Which is the court's into this. So no, and they say, well, you have to go to court and get that before we'll be able to deal with it. So something starts to drive it. Okay.
That's correct.
And so, if you have a will, you petition for what we call letters testamentary.
Yes.
If a person passes away intestate, meaning no will, they get letters of administration. Kind of the same thing, but it's just the concept of will, no will.
Right.
And then they swear you in, and you get those letters, and now you are the executor or the administrator. And now you have the authority. And that's usually a couple months later. But there's no time frame because let me tell you a couple of instances, and I have had people when I used to do probate, I have opened probate estates that were 20 years after death. And I still I still do that sometime in our trust planning. And here's how that works. So you can do it 20 years later, and you can not do it for 20 years. I mean, it can cloud the title, and you're in the real estate business, so you'll appreciate this. Here's what happens. Good example. Had somebody that passed away, 20 years ago, and they left the home to the child. The child lived there, lived there for 20 years. Now, some circumstance came up 20 years later when the house was going to be sold. Okay, when house goes to get sold to a third-party buyer, a defect in the title arises. It's now still titled in the name of the deceased because the person that lived there for 20 years, the child, never changed,
Never took any action.
never changed ownership.
Yeah.
Just lived there. Well, nobody objected because it was a child and it wasn't never up for sale. Nobody cared, right? I mean,
Yeah.
But now it's a concern because now it's a defect. You can't. Now, how do we sell this property to the new buyer? It's title insurance company crawl all over you about that. They want that fixed, and that's how it comes up. And so I have done this for people. Sometimes we go to put property in their trust, and we find this. So it's a simple thing to do because that late in time, it turns out that's the only piece of property in the estate. Everything else is would have. Typically people dies pretty much with nothing but that land. Because if there was money in the bank, it would have come up sooner, right?
Yeah.
Okay,
Yeah.
so we open up a probate estate. Actually, we can do something called if there is no will. Well, let me talk about that later. There's a couple abbreviated versions of probate we can use to do that. But typically, you got to open up a probate estate, and then move this asset from the deceased. Now you got to move it to the child because if there was a will saying it went to the child, and now the estate of the child can deed it to the new third party buyer. So
Right.
Right. I've had ones where grandpa died, owning a piece of property in his name,
Mm-hmm.
had a will and left it to his wife. She died and didn't have a will. Somebody's been living in it for 20 years. We have to go back and open grandpa's estate. Then we have to open grandma's estate because it went to her. Then we got to open up the child's estate as it went to grandma to her. And it get pretty convoluted. But it's fixable. You just got to fix
You
that
just got
chain
to
of
dig through the evidence.
You got to have a chain of title.
Sure.
And so now there are a couple versions when you have something like that where you have a sole piece of property that needs to be moved, especially if it's real estate. If there is no will, you can do something called affidavit affidavit of heirship. Okay.
Yes.
And then what that does is it passes it to the people that it goes to under the laws of intestate succession. Remember I said if you don't have a will, state of Tennessee writes one for you. So it will go to whoever those laws say it to. So if I passed away with a piece of property and had no will, and I did not have a surviving spouse, I have 3 children. That land would go to them, third. And if any of them were deceased, their third would through them to their descendants. That's what intestate succession is. And that's where it would go by affidavit of heirship. That's not even a probate action. That's more of just a plain real estate action. But if you have a sole asset, which is a piece of real estate that we want to transfer, like that case where it was 20 years later, there is a probate action called muniment of title. Okay, and muniment of title is just that. We go in there and say, hey, there's this piece of property. This is the only thing there is. We know where it goes because there's a will. And the will says it goes to this person, and we can pretty much move that piece of property pretty timely, a couple of weeks. And it is a probate action, but it's a abbreviated version of probate. It's not the full blown one. So depending on what kind of probate you open depends on what we have to move, but you can open them up 20 years later.
That's amazing.
Now, like I said, usually something precipitates it, the doing of it, before then.
Yeah.
Yeah. Because there's other assets, and you can't get at them. And so, how do I get at them? Probate estate. Here's another thing. Insurance companies. I told you, insurance stuff doesn't pass through probate because it's beneficiary driven, right?
Right.
Well, here's a trick insurance companies do that comes up often, and that is if you have a beneficiary instrument. Let's just say your life insurance.
Yeah.
Because that's the one everybody can associate with, and you say, my beneficiary is my wife, and that's all. I mean, you can name a primary, and you can name a secondary and a tertiary. You could name, okay, it's my beneficiary is my wife. After that, it's going to be my 3 children, a third each. And after that, if none of them are around, I wanted to go to the Star Theater Community for the Arts, Center for the Arts, to a charity. So you've named multiple beneficiaries, right? So if one fails, it goes to the next one. Well, what's classic is people will name my spouse as the beneficiary, and then when that person dies, okay, we have this policy. Who's the beneficiary of it? Well, it's the spouse. Well, the spouse has already predeceased, right?
Right.
Insurance companies will look at that and say, okay, there is no beneficiary because the only beneficiary we had is now deceased because beneficiaries don't pass. So it's not like, okay, my dad was the beneficiary, but he died, so that means I'm the beneficiary because he died. No, it doesn't work that way.
Right.
It can work that way, but it doesn't unless you say it in the beneficiary designation. So the spouse passes away, and so the insurance companies there is no beneficiary. So if there's no beneficiary, we will only pay the death benefit. They'll pay it, but will only pay it to the probate estate. Now, I've had that happen with people who had trust, and the whole idea of avoiding probate is a trust. And if you don't do beneficiaries right, you could find yourself with a trust having to open up a probate for that life insurance policy. So that's something we always advise our clients about. We visit these beneficiary instruments, and at the very least say, okay, if you want to name your spouse as beneficiary, that's great. But let's name a secondary beneficiary the trust. And now it's always got a place to go. We don't have to put up with that. So, but insurance companies are pretty classic about that, and it's a hassle. So, but again, we open it up for just this one asset, and we can usually do that pretty quick. Now the drag is the insurance company.
Talking about placing things in the trust or funding
Yep,
the trust, as
yep.
you've talked about. You've talked a lot about real estate and bank accounts, insurance, life insurance. How does it affect personal possessions?
Oh, good. Yeah, personal property.
Yes.
So when you think of personal property,
Because some people have quite a lot.
let's define what that is. There's only two kinds of property in all the world.
Yes.
Real property, which is land and everything permanently attached.
Yep.
And personal property, which is everything else.
Right, exactly.
And it's like, is that really a legal definition? The answer is yes, it is. That's
We used
exactly
to call
what
it,
is.
way back in the auction pit, we call it chattels.
Yeah, everything that's not real.
Yeah.
Personal property is everything that's not real.
Yeah.
Real is land. So that's your pots, your pans, your tables, your chairs.
Yeah.
You name it. Your untitled property, your stuff. I call it your stuff.
Yeah.
And if you got so much stuff, like my house is polluted with it. Like,
Yeah.
you know what I mean?
But I'm talking about even like large items, tractors and lots of them,
Sure.
and high dollar items, boats, whatever,
Gold bars.
gold bars, yeah,
Stock certificates.
Yeah.
I mean, that's
Coins.
all personal property.
Yeah.
Now, surprising, and it's a good topic. Let's go. Take us a few minutes. We can put that in with a stroke of a pen. We put in all your personal property that you own by possession. We put it in. Now, let's talk about this owning personal property by possession, because it's a weird concept. So let's go over it.
yes,
You have a house full of stuff. Okay, you got pots, pans, tables, chairs, stuff.
right,
If I ask you to prove you own that, I mean, I don't know how you could do it. You might show me where you bought here's the receipt where we bought it. And my argument would be, it says you bought it, doesn't mean you own it.
yeah,
It could have been a gift, right? But anyway, so how do you own property? You own it by possession. You ever hear the old adage that old timers would say, and some still do, that
Yes.
possession is 9/10 of the law.
that's right.
Well, what does that really mean? Well, I'm going to tell you what it means. You're sitting here right now today. You got this print blue shirt on, and
Yes.
if I ask you the question, how do you own that shirt?
It's my shirt.
And the answer is, I possess it, and nobody else claims it.
Yeah,
And so you own it by possession.
correct.
Right? And so it's this weird concept. If you go buy a TV from Walmart, great big old screen TV, and like I tell people, they say, if we put we do an assignment of personal property where you put all your stuff into the trust. And so 2 years later, after you write the trust, you go to Walmart, you buy a big old 100-inch flat screen TV, and you're sticking it in the back of the truck, and you think, oh, I need to run down to Stan's office and put the TV in the trust. And he says, no, take it home, hang it on the wall, and possess it. It's in there. So when we talk about ownership
Yes.
by possession, we are talking about a snapshot in time. So the stuff I own, it goes down every Friday morning as I'm over here when I carry the garbage out to the end of the street, right? My stuff goes down a little bit. And it goes up practically every day when my wife goes to Walmart, right?
Yeah.
So it is a moving target, up and down. Stuff comes, stuff goes. It's there, it's not there. At my death, there's a snapshot in time, and everything I own by possession is in my trust from that moment.
Yes.
So a lot of times I'll say, you think about the TV I just used. It's like, okay, this reaches into the future, kinda. It doesn't really reach into the future. If I pass away with that TV hanging on my wall, it's in the trust.
Correct.
So it didn't really reach in the future and say anything I'm going to buy in the future is in my trust. I mean, it's going to be in my trust while I own it, but if I ever get rid of it. So that's what they mean by 9/10 of the law is possession. If you possess it, you own it, because you can't prove title ownership. Now, some personal property you can, like vehicles, boats, airplane.
Right.
Tractors and stuff don't typically carry a title, and all that is personal property.
That's correct.
Guns, firearms.
Cattle.
Cattle, anything that's not real property is
Yes.
personal property. Now, the stuff I talked about, like in the bank, we can't pass that in there with our assignment of personal property, and the reason is that is personal property, but it's a personal property that you have a contract with a third party, like the bank, with the financial institution. So excellent question. We put all that in the trust too. And so in your trust, if you want to say specific distributions, like, I want my son, does all the bush hogging, so I'll leave him the tractor and all the implements and stuff that hooks to it.
Yes.
And I want to leave my guns to somebody else, and I want to leave I got a baseball card collection. I mean, you name it, all your stuff. You can say where it goes. You don't have to have this exhaustive list of everything. Some people just say all the personal property gets divided among my kids, and we put in trust all kind of ways to divide that up. We can say, you can have a round robin where people sit around and say, okay, I want that thing of Dad's in the garage. I want that motorcycle in the garage, and I want his tools. And somebody else says, I want this. And then, you go around the table and you distribute personal property. And by the end of the day, you got a bunch of stuff you can't even give away, right? At least in my house. And, so your successor trustee has the authority and the discretion to maybe have a yard sale and then divide the money. That's easy. But then there's stuff you can't even sell. So you can take it to Goodwill or you take it to the dump. It's got to go somewhere. And we have to have discretion to deal with it. So this concept of personal property, it's a lot easier to put into a trust than it sounds. It sounds like the most ominous thing to put in, but it's not. So you don't have to make this long Excel spreadsheet of everything you own.
Right.
Now, if you want certain things to go to people, it might not be a bad idea to itemize it and take a photograph of it so they know what you want to go to them.
That's
that
correct.
Kind of stuff. Or describe it with enough particularity that your successor trustee knows what you're talking about. So if you got 20 of those shirts and you say, I want one of the shirts this shirt to go to my child, we don't know which one you're talking about.
Right.
Stuff like that. So it's really very simple. It's an excellent question, and it's a weird concept. Owning property by possession is an odd concept. It's a legal concept. It comes from our common law because like you said, how you answered the question, why is it yours? Because I have it.
Yeah.
I have it. I exercise dominion and control over it. It's mine. And, it's kind of like when you change your name in the old day, under the common law, you are who you say you are.
Yeah.
There's no business of going in and changing your name.
Yeah. The more we talk, the more I feel like that I'm learning just how important it is to make these decisions and handle your property and see that it's handled the way you want it to be handled after your passing. Because let's face it, we're all going to pass here one day.
Yeah, let's say, well, if I pass away, well, that's a when.
That's a when.
Now, if you go into the nursing home or long-term care, that's an if.
Yes.
That doesn't happen to everybody.
Right.
Or if people say, well, you become incapacitated, then you die. Not everybody becomes incapacitated.
No.
But passing away is a when. You have to embrace your mortality. And, I think I mentioned maybe in the first show, in my PowerPoint, I have a quote from Anthony Hopkins, the actor, where he pretty much says, none of us are getting out of this alive.
That's right.
And that's right. And so you hit the nail right on the head when you said, if you want it to go the way you want it, if you have something in mind. Now,
Yes.
if you're a guy and the guy says, I don't care, they can fight over it, I'll be dead. Well, then none of this is for you. You just go get another cup of coffee, and no sense listening to what I have to say because this is not a fit for you.
Yes.
But if you have in your mind how you want your stuff to go, either just to give it to them or to take care of people, like minor children, if you have a mind, if you want to make sure it goes that way, you need to memorialize it some way.
You may remember not too long ago, it's been a little while ago now, I guess, there was a book that came out, How to Die Broke. Do you remember?
I've heard of it.
Have you heard of the book? Yeah. And I'm assuming it was about some kind of estate planning and getting rid of your assets so when you pass, you have nothing.
Well, if the estate planning actually distributes it after death, but,
Yes. Of course, you have nothing at that point.
It reminds me.
You don't.
I had a client one time, we were talking about protecting assets from long-term care. Mm-hmm. And he said his plan was for the last check he ever wrote to bounce.
Yeah.
And so, I thought about that and I said, I think that's a grand plan.
Yeah.
The problem is it's an incredible act of timing.
Yes, you don't have an idea when that time's going to be.
If you jump the gun,
that's why it's so important to do the kind of planning you're talking about.
That's right. But you can give it all away.
Yeah.
After death.
Yes.
Which is what you want to do. So, and again, if you pass owning all this stuff, and you don't say where it's going to go, other people, meaning the government through the judicial system, the court is going to decide where it goes.
And let's face it, once you pass that death mark, you don't need it anymore anyway.
That's right.
So,
you don't need it, but like I said, you may have family that does. Because all those possessions are what you need during life.
Exactly. That's right.
It's like when we do these special needs trusts for people that have special needs.
Yes.
They can't inherit
Yes.
money. If they do it, they lose their benefits because they can only own a certain amount, right? And if you have to own, and the rules are similar to TennCare really for the SSI rules and SSDI. And so if you have somebody's special needs and you write in your will, I leave that child $20,000. That's not the way we want to do it, because if he inherits that money, you've triggered a loss of all his benefits because you pushed him over the cap for what they're allowed to own. They'll disqualify him in a heartbeat.
Yes.
They're pretty harsh. They're pretty unforgiving when that happens. Now, what you can do is you can open up a special needs trust that holds property for that child's benefit. It's not his; it's for his benefit.
Yes.
You can put $1 million. So we put in a will or a trust that I leave this property to Joey's special needs trust, and now it's his, and he can use it. So I'm trying to answer what you brought up. It's just a roundabout way, and that is, when you deal with a special needs trust and you leave money in it for this person, it's not theirs, and they don't have any control over it. But it's like, if you leave money, what is money used for? I mean, you don't need money, right? People say, yeah, I need more money. You don't need money. What you need is a place to live. What you need is food from the grocery store.
You need what money can buy.
What you need is to pay the electricity for your heating, and
Right.
What you need is the money to pay for the things, the necessities of life.
Right.
Now, this special needs trust, you put property in there for a special needs person. It's for their benefit. Can buy all that stuff, but it's never theirs, and to trigger this ownership of excess assets, which trigger loss of benefits. So when you talk about now I kind of forgot what we were talking about. We're talking about inheriting this stuff. You don't need it once you're passed away, but during life you need what it does for you. To be taken care of.
Right.
If you're going to leave somebody a bunch of money in the bank, that's great. But that money is not what they need. What they need is what that money will buy to keep their necessities at least, and maybe the luxuries. Enhance their quality of life, stuff like that. So that's the whole. You're right. That's the whole concept of it. You think if you spend your life building up this wealth. And I mean, let's just talk about that, because it's really kind of a sobering thought when you think about it.
Sure.
Everybody works for a living, technically. Maybe not so much these days, I don't know.
Good normal people do what they're supposed to do.
We won't go there, but I mean, you develop some kind of trade or career or something. You do something for 20, 40 years, pretty much.
Yeah.
And you work and you get a paycheck one way or the other. So it doesn't matter how that's right. But you save and you buy things. You save up and you buy a house.
The American dream.
You get married and have kids and you own a home. And typically you sell that home and buy a bigger home and progress through. That's what real estate does.
Mm-hmm.
And there's incentives when people do that. Ways to avoid capital gains by selling it and rolling it into another piece of property, stuff like that. So you do that and you put money in the bank, and sometimes more property opens up, or somebody comes along, you decide to invest in something, and it's successful. And when you get older, you have spent a lifetime accumulating this stuff. And it is yours. It is yours. You need to reap the rewards of what you have done. And so we went, okay, I want to spend this in my retirement years, but a lot of people have more than they can spend. I mean, look at real estate. I mean, just in the last year or two, it has just skyrocketed in value. It's not hard to have $500,000 piece of property.
Not at all.
It is not hard at all. You got something that's, well, I don't want to be insulting, but even a Tobacco Road tar paper shack kind of thing goes for $50,000 or something. Just
Sure.
a lot. A lot with a house on it goes for a lot, and the person buys it just went and bulldoze the house and build something else, right? So if you pass away with property, you'd be surprised at what it's worth. And now you spent your entire life with this wealth.
Mm-hmm.
And it's to take care of you, it's to take care of your family. But now the thoughts start coming into our mind that if something happens to me, I want this to go to my loved ones. It's a natural human thought.
Sure.
I can't imagine. Every now and then somebody says, I don't care, my kids can fight over it, I'll be dead. I really don't get that logic and can hardly wrap my brain around it. But if that's your thought, then sit back and relax. There's nothing you have to do. There's no planning for you to do, because that's what will happen.
Right.
You'll pass away, and if you have anything, they'll either fight over it or agree on it. But if for the 99% of us who think a little more like, I want to take care of my family, I want to take care of my spouse if I'm the first to go, so they are comfortable and have plenty to live.
Correct.
We want it to go to them, and the only way to ensure it goes to them the way we want it to is by sitting down, embracing your mortality, thinking about what you have, thinking about where you want it to go, and memorializing. When I say memorialize, we have to reduce it into an enforceable instrument. So when people are putting together plans with me, here's the overall advice I give them on how to come up with the plan. I say, okay, if you want to do a trust, I can draft the trust and put all the trust language in there as necessary, but I don't know what your descent and distribution is, where you want it to go. And so here's the best way you can describe that to me. If you will fast forward in time to your death and explain to me what the ideal result is, that's what I can work with. So let's go forward and say, okay, I'm going to, hopefully 20 years from now, I pass away. Here's what I want. I want my land to be there. It's still intact. I want my kids to have it. I want what we call the patriarchal family in scriptures. I want to pass the land from generation to generation. I didn't get any, and I figured, well, it has to start somewhere. So I guess it's just going to start with me.
Yes.
So I have some property. I want it to go to my kids. If my wife is still alive, I want her to have plenty of funds to have a comfortable life. I want, I don't want to have any debt that they have to deal with. I have this ideal plan at my death. And so if you tell me what that is, I can back up and put all that in the trust, and we memorialize what you want done.
Yeah.
And if you can get as specific as you want or as general as you want. Specific is like, I got this prize shotgun, and my grandson and I used to shoot a lot and skeet shoot a lot, and he really liked that. It's a Ducks Unlimited gun.
Sure.
And he really liked that. We loved shooting together. We bonded. That was a great activity. I want him to have my prize shotgun. Okay, you're being real specific. You're saying, I want this shotgun to go to this person.
Right.
You can do that with any property you have, or you can do it with sums of money. I got 5 grandchildren. I want them all to get $10,000. I mean, you can, or you can be as general in this thing as you want and say, I got 3 children. Everything I have, real, personal, or mixed, I want to go to them. They each get 33.3% each. They get a third of everything.
Yeah.
That's real general. All of that's fine if that's what you want.
Right.
Now, but so if what you want is specific, go for it. You can do that, and you can do it all probate free. I mean, you can. And I haven't even got to the part because we're running out of time. But I was going to talk about when we distribute property in a will. In a trust, and this will be next week's topic. When you distribute property in a trust, you can put all kind of terms and conditions on it you want. Remember I said in a probate process, when you distribute, it is an outright distribution. They get it.
Yes.
Here it is, yours. Now, you say, hey, here's the family farm, but I kind of like you not to sell it because it's been in the family for years. Well, once it's the son's, it's the son's. Once it's deeded to him, it's his. There's no terms or conditions on that.
Right.
He can turn around and sell it the next day. Now, he might not, maybe he's family-oriented like you, but you're relying on that.
Yes.
So if you want certain things, you can put terms and conditions on property, not through the probate process. You can do it through with the trust all day long. Now I'll get to later on. There is a way to put terms and conditions in a will. It's called a testamentary trust. That's inside the will. But I always take the position: why put a trust in a will that's opened and governed by a probate court when you can have a trust that's 100% probate free?
It makes better sense.
It's an old school way of doing stuff, and some attorneys, I'm sure, would argue, but there is a way to do that. But
attorneys argue? Are you kidding?
But when you have a trust, you can put all kinds of terms. You can rule from the grave as much as you want, which I don't necessarily advise, because the more you rule and the more you put conditions on it, the more things we got to think about, right? Yeah. But you can put terms and conditions on it, and I'll bring that up next week, because that's the beauty, in my opinion. That is the number one big advantage of the trust. And probate avoidance is a great tool. I love it, and that's a big advantage. But what really got me into this business was the ability that we can solve a ton of problems. Remember I mentioned if you have an adult child who's got a drug or alcohol problem, you leave him $50,000 because you don't want to inherit him. You can be the instrument of his destruction, right? Especially if it's a drug habit, right?
Yeah.
But now let's leave it to him and conditionalize it. And we leave it with somebody else to control it. And say, you can get this $50,000. You can use it for rehabilitation.
Right.
You could use it for education. You can use it for anything other than a drug or alcohol related problem.
Yeah.
So it's conditional. And now,
so if you have a person who's a special needs person and they've been addressed in the trust somehow, then you've got an administrator of the trust that oversees that continues on. Is that what happens?
It's a special needs trust, so it will have its own trustee.
Trustee.
So if I have a special needs child and my trust and I have a special needs trust for a child,
yes,
typically you fund that trust at death. And the reason I say that is because you don't typically fund it at life, because if I'm the parent of a special needs child, I'm taking care of the child while they're alive. I'm clothing the child, housing the child, feeding. I'm doing everything.
Yes.
But the big question is, what's going to happen to this child if something happens to me? So I have this trust for him, and at my death, I will leave a certain portion of my wealth to his trust. I will designate in there who the trustee of that trust will be.
Yes.
That person now controls that trust for that special needs person. That's right. So you're right on the money.
Very good.
And so anyway, we're going to talk about how you can conditionalize and the problems you can solve. I said you can divorce proof it.
Oh, now, how would you do that?
That gets a lot of people's attention. We do that. You can protect it from your kids' lawsuits or creditors. Like I said, you can protect it from a spendthrift. You can meter it out to them, or you can conditionalize it. And when you conditionalize, I was using a drug-addicted child. If you incentivize that, it's like you get this property, but you don't get it as long as you've got this drug or alcohol problem. Well, first of all, you've protected the property from going to that problem. Mm-hmm. Second of all, you've incentivized the child cleaning up their act, so to speak, changing their lifestyle, right? I mean, especially if
which would be a good thing.
It is a good thing. So, I mean, it's kind of a win-win situation, but you kind of put the ball in their court, which it always has been in their court, to either partake in those kind of activities or not. But now, when you have incentives to clean up, I mean, I think I've seen them work. I've seen work. When you have a drug addict and they don't have anything, and the family disowns them, their life is pretty much hopeless and destitute, right?
Yeah.
I mean, there's not much to look forward to.
Yeah.
I mean, because they're chastised, they're cut off, typically, not always. And I mean, I know that breaks a lot of families up. It's like, I love my child, I don't want to disown them, but they have this bad problem, and I can't give them. Anyway, sure. I get the reasoning, but if you change those circumstances, say, listen, you can have a third of this estate, but I am not funding this activity that I don't condone. I'm not funding a drug habit. I'm not funding an alcoholism. I'm not funding all these negative things. Now, if you want to use some of this money to rehabilitate, it's yours, or whoever's controlling the money has the permission to spend it on that.
Right.
And I'll even put in this: if 3 or 4 years go by and that person in charge of your money says, I don't see any drug or alcohol related problems, I'll have the thing have self-exacting terms that now you can have complete and total control of all your inheritance, because the problem I was trying to solve isn't there anymore.
Right.
So this incentive is powerful. So if you got somebody like that and they said, I can inherit a bunch of money and I can clean my life up and I can kind of live a regular life, I think that is a motivating factor.
That is a motivating factor. That's a great motivating factor for a lot of people. Yeah. And I'm sure you have seen it work.
Yeah. Looks like we're getting close to the end of the hour, so I'm going
you got a couple of minutes left.
Yeah, I'm just going to go over, I just want to refresh people's memory and tell them I have this seminar coming up on July the 29th, which is a Saturday, 10 o'clock. We call it Will's Trust in the Nursing Home. That's going to be on the square in Pulaski at the Star Theater. Big venue. We got a lot of room to spread out there. If you want to talk to me and talk about any of my topics, call me at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. Or you can go to my website, which is Estate Plan Stan, and you can see my calendar and when things are coming up and all that stuff. So in my last minute, I just want to mention quickly, I'm associated heavily with the Star Theater, community theater.
Yeah, that's a great place
Center
over there,
for the Arts.
on the square in Pulaski.
And I don't want to pay the price if I go home without shouting out what's happening over there real quick, because my wife is heavierly involved, more heavy involved. Anyway, coming up though is a show called Newsies. It's a musical. It's about the newsboys in the 1899 and the great news strike. It's a musical. It's a pretty cute show. But it's going to be playing from July 14th to the 22nd. We typically do on Friday and Saturday nights, but the tickets are on sale now. So
that's an awesome historic theater over there.
It's pretty cool. So call and get a ticket, because these things go fast. There's a lot of kids in it, and so families buy the tickets up pretty fast. So get on that list. And the other thing we have is on June 24th coming up, just next Saturday, I guess, is a songwriter workshop. And it's a $20 thing, but we got a new popular songwriter here in town that comes, and it's just kind of if you're creative and you're into music, and you wrote a song or two, it's a good opportunity to come and give it a try. So
very good.
You can call my office to find information about that.
That office number again?
931-363-7222. We're right next door, and we can get in touch with the people that are there to deal with it, and they'll tell you all the information you need. So, all right. Well, it's always a pleasure, Jeff. I enjoy talking to you.
Stan Pierchoski, everybody, and
always amazes me how fast an hour can go by.
It goes by quick, doesn't it? We've enjoyed the morning, and hope you have, and you'll be back next Friday with more information.
With more bulletproof estate plans.
That's right. And thank you, buddy, for coming in this morning. And don't forget that phone number again, 931-363-7222. Estate Plan Stan.
Always a pleasure, Jeff.
See you next time.